And okay, just clicked over to 6 o'clock. So welcome everyone. I see we have 17 people. I know last time I looked, I think there were close to 40 that were registered. So I want to welcome you all to tonight's session. This session is on the top tips for your deficiency notices. Obviously, see that we're recording. So if you missed something, if you feel like you want to go back and, take notes or whatever you need to do, we'll have the recording available. For those of you who have been with me before, you know that we always put all of our recordings in our Dropbox. So I'm doing that. So I will be doing that tonight as soon as this recording becomes available, as soon as Zoom sends it to me. And for those of you who have asked about one-on-ones with me, I have sent the link out to my calendar a few times. As you know, I'm kind of booked up. As a matter of fact, my earliest availability is not until Thursday. I think I have one or two. I just made a minor adjustment. So I actually opened up a slot. So I think I have like maybe 2 slots available on Thursday. If you do book with me, please keep your time because you take a time from somebody else who really wanted it and needed it. And be prepared with your questions, all of that. So without further ado, because I know there's going to be a lot of questions. I know that you all don't want to hear me talk a whole lot. So I'm just say these couple of things. If you have a question, type it in the Q&A box. If you've been with me before, you know I moderate the questions. I might miss something if you put it in the chat. We don't miss questions. So put it in the Q&A box. If you want to pre-fill those questions, because there's already 2 sitting in there waiting, we will get to them. So if you came in with questions, you can go ahead and type it now. I will get to every question, I promise you that. So without further ado, I want to introduce Ms. S.L. Owens, who is from the John Marshall Law School at UIC. She is a cannabis attorney, and I am excited for her to be here, and I am excited for you all to hear from her. If you're not aware, JMLS is another partner with DCEO that's providing free technical assistance to applicants. So I will turn it over to you, SL.
Thank you so much. I am so happy to be here. I am going to get started with the shared screen for my presentation, the first part of it. Here we go. All right. So today's workshop, as you all know, is on top tips responding to Illinois deficiency notices. I want to, before we get started, just give you all a little bit of background on what the agenda for today is going to look like. If you came to my first workshop at UIC last week, then you are familiar with my style, which is to start off with a law lecture that introduces the legal concepts to you before we hop into the Q&A. I'm expecting the Q&A to be very engaging today because I know this is a very hot button issue and folks have a lot of questions, and I am looking forward to staying until the very last question. So we will get to that. But I do want to start off by giving you guys some of the, as we like to call it in the legal industry, the belts and suspenders of the law. So I'll start off introducing myself. I will talk a little bit about what the Social Equity Cannabis Initiative is, and then I will jump into these top tips for you all. We will have a brief break because in this virtual world, we need those breaks, and then we will hop into the Q&A. So me, S.L. Owens, I am a Chicago native. I was born and raised on the West Side in the Austin neighborhood. I am also an experienced business and regulatory attorney. I started my business law career working for some of the big law firms across the United States in Wisconsin, Colorado, and Illinois, which means I've taken a lot of bar exams. After that, I came back home to Chicago and started a small family-owned law firm where we represent represented small business owners and entrepreneurs. After that, I was appointed to teach at UIC Law School in their legal clinic, the Community Enterprise and Solidarity Economy Clinic. This legal clinic is near and dear to me because, as a West Side native and a native of the Austin community, I know how lacking our communities can be in having access to legal services, particularly in business law, because in our country, you do not have a right to counsel in civil matters, only in criminal. So I love working with this clinic for two reasons. One, I can give back to my community. And then number two, I am able to help influence the next generation of attorneys and help them to become culturally competent as they embark on their own legal careers. So I love mentorship. And so this is a perfect fit for me to teach in the clinic while also teaching in the community. Just a little bit about the clinic. It is based out of UIC John Marshall Law School. We most often represent worker-owned cooperative businesses, nonprofits, and small businesses. Most of our companies and nonprofits that we represent are really socially conscious and socially aware brands who are working to not just benefit themselves and enrich their business goals, but to also enrich the community. Most of our clients promote a core value system of equity, democratic decision making, and building sustainability in their neighborhoods. So if you're wondering what are some of the attributes we look at when we are taking on new clients, those are definitely some of the criteria. We usually accept new clients twice a year, in January and August. I know it's February. So we are at the moment closed from taking new clients because we have filled up our docket for the semester. However, we do accept new applications throughout the school year. And I do encourage you to submit them because sometimes space does open up during the school year. But you definitely can look forward to hearing from us, usually around January or August, about whether we can accept your case. So the Social Equity Cannabis Initiative. So I was specifically recruited to UIC, to the law school, to work on the Social Equity Cannabis Initiative. Partly, probably one of the most important reasons is because of my regulatory background. So I have substantial experience in the franchise, distribution, and supply chain industry, which for those of you unfamiliar with franchising, is a very highly regulated area of law. It is regulated all across the globe. So I have international law experience in regulatory law, and it is regulated in pretty much most of the states, including Illinois. So it's one of those areas like cannabis law, to where there's specific laws, rules, and regulations at every government level in every jurisdiction. So it was a natural fit for me to pivot into cannabis law, especially when I was practicing out in Denver, Colorado, which is where I was based right before coming home to Chicago. And so when they recruited me to work for the initiative, we teamed up with the Department of Commerce to build this initiative. And the whole purpose is to reduce the legal barriers of entry into the Illinois cannabis market. So we primarily offer three buckets of services. One, workshops like tonight and materials on cannabis law related topics, which I will be sharing with you this evening. We also provide brief advising through email. I will share a link with you this evening where you can fill out a form to request brief advising. That is not legal representation. It is exactly as described. It is brief advising to help connect you to resources and to provide you with brief answers to your questions. And then we also provide legal representation through our clinic application process. The main goal of the initiative is to provide timely and equitable access to legal information, which is why I'm so grateful to Trisha for helping me quickly organize this workshop for you all in the middle of your deficiency process right now, notice process, so that you could get this timely and equitable access. So the meat and potatoes of tonight. So top tips for responding to Illinois deficiency notices. Before we delve into the tips, I want to cover a few things. The first thing is the scope of this workshop. So the scope of tonight is really in three categories. One, I want to provide you with the legal context. I want you to understand what the legal context that you're operating in is right now, because this is how a lawyer would come to think about this process. And this is how a lawyer would approach it. Secondly, I want you to think about what the legal framework is. Here, we're talking about how do you navigate the whole world of deficiency notices? What legal rules and parameters are there? What are the guardrails, as we could call them? Whereas in the context, we're talking about what are the systems in place? Who are the parties and the players? And legal strategies is the third area. So here, we're talking about what are some concrete strategies that you can use as a self-represented party, because most social equity applicants don't have a lot of access to legal resources. So that is the goal. I want you to leave here thinking like a lawyer. I want you to be equipped with legal context, legal framework, and legal strategies. So what is the legal context of deficiency notices? All right. So as you can see, I put together this chart to sort of help you all understand what is the greater world that you're operating in. It's really easy to get caught in the minutia of it, which is important when we're deploying strategy. But before you can even get to strategy, I think you all really need to understand the full context of what's going on around you, because that is how a lawyer would approach this. We think, where is this particular legal process? How does it fit into the whole regime of the legal context in Illinois? So here we have the license application and deficiency process, which you see right in the middle. And that is administered through two state agencies, the Illinois Department of Agriculture and the Illinois Department of Financial and Professional Responsibility. Then you have, outside of that, the court process. The reason why the court process is outside of the deficiency process at the agency is because the courts, as you all may have been following in the news and as some of you may have been engaged in, the court is the guardrails to the work that the agency is doing. The court system is what determines whether agencies are acting within the law, which we'll talk about in the next slide. So after that, we have the legislative process. So you'll see that that's outside of the court process, because the court really helps interpret the law, but the legislators are the ones who make the laws. And then way outside of that, you'll have the advocacy and lobbying process. Another reason why I wanted to present this slide tonight is because cannabis law is a rapidly changing area of law. And it is, I mean, sometimes it feels like it's changing week to week. I'm sure some of you feel the same way. And this chart kind of helps you understand two things. One, it helps you understand, okay, how do I navigate these systems? So if you are trying to work with the agency, you need to understand that sometimes you may need to work with the court process to get the agency to act in a certain way. Sometimes you may need to work with the legislators because it's really the law itself that needs to change. And that's not really something a court typically does. A court doesn't typically change law. A court can tell you if a law is constitutional or not, but the legislators are the ones that change the law. And I know that folks have been pretty unhappy with certain aspects of the cannabis laws and the social equity laws here. And that's why, unfortunately, you have two jobs, the job of being an applicant, but also the job of being an advocate and making sure that you're staying engaged with the legislative process, which we are in the middle of a new legislative process. So you want to stay engaged through the end of May so that you can make sure that things that you found to be unfair. So for example, I hear a lot of complaints about the 10 days. Is the 10 days fair? Is the 10 days even lawful? Well, that is a thing that you would possibly take up in court if you had legal counsel. And I'll talk about that soon. Or you would take it up in the legislative process. If you want this to change from 10 days to 30 days, then that is something that needs to be put on the board with the legislators as they are amending these laws for the future. Secondly, this also helps you know how to navigate the legal system. This is how a lawyer would think. Okay, is it best for me to take up my issue in court? Is it best for me to try to take up my issue in the agency? Is it best for me to take it up with my local legislators? Or is it best for me to take to the streets and advocate and lobby or protest? So these are just some of the things to think about when you're thinking about where am I in the process? How does this deficiency notice fit in? And how can I work the system so that I can be a better advocate for myself and push the system to work for me? All right, now we're going to get into the legal framework. So, cannabis law really falls within a couple of sub areas of law, including this deficiency process, right? So you have the Cannabis Regulation and Tax Act, which is front and center, and that is the law that was passed by the legislator. And then you have these kind of mini categories of law that I need to make sure that you guys understand as you're trying to work the system as well as use strategy. So you have administrative law. So the way to think about this is the legislator enacts the actual act, the tax act, the Cannabis Regulation and Tax Act, so the CRTA. But the CRTA is really just a framework for how the programs will work. Each agency has to set up its own what's called implementing regulations, which many of you are seeing in your deficiency notices. So sometimes you see citations that say you're deficient with the CRTA, and that means they're saying in your application, they're seeing that you are not complying with or conforming to the actual legislative act that was passed by Illinois' legislator. Sometimes, though, you see citations to the Illinois administrative codes from the Department of Agriculture, for example. So that is what's called administrative law. Now, to understand how these things work together, the legislators inside the CRTA, they give the agencies the authority to implement rules that are more specific to how the program will work. So, for example, in the act, you'll see the CRTA tells you what are some of the categories of what a social equity applicant is and what are those points going to look like. But in the administrative rules, you'll see more details about how the actual application process will work, what will be the timelines, things like that. So that's just a way to understand, like, if you have an issue with how things are going, is it the administrative law or is it the CRTA itself that needs to change? Because the administrative laws passed by the agencies, those laws are supposed to be informed by the Cannabis Regulation and Tax Act. Then the other bucket you have to the other side is called due process. If you were in my workshop last week, we talked about due process. And due process is essentially, at a bird's eye view, due process is essentially your right to fairness in proceedings, including with state agencies. They have to treat you with fairness. That means they have to pass rules that are fair and they have to implement them in a fair way. So this is a right that we're given through state law, and we're also given this right through the US Constitution. So the Illinois State Constitution gives us this right, and so does the US Constitution. So one way to think about how due process works in this framework is due process is what says ultimately will be the decider of whether the things that the agency are asking of you guys is ultimately fair process under the Constitution. So usually these are things like, did you have right to a fair hearing? Did you have right to a fair appeals process? Those types of things. And so once again, let's go back to the 10 days, which is one of the big complaints. Is 10 days enough time? Well, is it under due process law is one of the questions that you could be asking, and that you likely would work with an attorney to help you figure out. The fact that the CRTA does not have an appeals process is also a potential due process issue, because essentially, if they make an error at the agency level on your application, you have to go to court in order to sort out that error, which we saw over the last 6 months. Well, that could be considered a pretty unfair process. So these are some of the things that are percolating in the background that really is important for you to understand. What is this legal framework that I'm dealing with? Because you have the application itself, you have the supplemental responses and deficiency, but you're not stuck with those four corners. You also have the law to protect you. So I just want to make sure that, I'm giving you sort of the full picture here. Now at the bottom, you'll see another layer in these red circles. These are other parts of the legal framework of cannabis law here in our state. So one of these buckets is equal protection law and the Illinois Special Legislation Clause. Again, if you were in class last week, this is a repeat, but this is another area of law that has to do with your rights under state law, as well as under the state constitution here in Illinois, as well as under the US Constitution. So equal protection laws at a high level, not getting into the nitty gritty, is essentially has to do with your rights to be treated fairly under the law. So, whereas due process has to do with the fair process and making sure that everyone has access to fair hearings and fair administrative rules, and making sure that state agencies aren't, or federal agencies aren't acting in a way that's considered arbitrary and capricious, which is a legal term of art. Equal protection is all about whether certain groups of people are being treated more harshly under the law than other groups of people, whether laws have disparate impacts on certain groups of people. So let's keep using this 10-day notice so that we can use that kind of as our tool. So for example, is the 10 days rule, is it more helpful to some groups of people than other groups of people? And under the law, perhaps that could be an equal protection issue. Another way to think about this in terms of current issues is the veteran status category, which I won't get into a lot of detail today because that's not our main topic, but it did come up last week, and it is related to this overall framework, which is that lawful under Illinois law? Because in Illinois, we have a law that's very similar to equal protection that has to do with whether certain groups of people can have special benefits conferred on them that should be generally applicable to everyone. Okay, so this is important because this is why there are constant changes on a week to week, month to month basis as you are in the middle of this process. So if sometimes it feels like you are drowning, you are not alone. You have experienced regulatory attorneys like myself who are treading water, keeping up with all of the many legal issues that are surrounding processes like the deficiency notice process. Another way to think about the equal protection is to think about whether the lack of a deficiency, the lack of an appeals process. You know, that's another way to think about it. Is that lack of an appeals process benefiting one group of people over another? So it's just thinking about what are the impacts of the way laws are applied. Maybe the law itself was fine, but it's the application of the law that makes the law not okay. Now, the last bucket is the Freedom of Information Act, also known as FOIA, and the Illinois State Records Act. These two are pretty important to helping you get access to information. In the legal industry, we tend to call these sunlight laws, sunrise laws, all type of versions of that, which basically means citizens' right to put a flashlight on the conduct and behavior of government officials and state agencies and federal agencies. So I want you guys to start thinking about getting familiar, especially if you're self-representing and self-advocating, with how to use FOIA and how to use the Illinois State Records Act to request information that you should be able to get on a timely basis from these state agencies that are regulating the cannabis business licensing process, because they are required by law to disclose certain public state records to you, because those records under the law of Illinois, they don't belong to them, they belong to the people of Illinois. So I just wanna make sure that we are on the same footing when it comes to what is the legal framework and what is the legal context. Now, we're going to move into top tips for responding to Illinois deficiency notices, which I know you're eager to see. But again, those last two categories are really important backdrops to helping you think like an attorney, because that is all the information that an attorney would go into this next part, the legal strategy part, thinking about. So the first tip that I have here has to do with how to organize information like a lawyer. Before we jump into this, I am going to drop a link in the chat that gives you guys access to all of the key documents that I'll be using so that you can follow along at the same time.
It looks like that link just came to me.
Oh, here. Oh, okay. Let me do that again. Thank you.
I'm glad I was paying attention.
Yes, thank you. Before we get a lot of hello, SL. All right, everyone, you should now see it. It should be available to attendees too. It's a box link. And the first document on there that we're going to look at during this presentation is organizing like an attorney. So I'm going to give everybody a few seconds to get access to that link. I'll also be showing it up here on the screen, but I know how eager everyone is. And so I figured I better go ahead and share it while we're presenting so that you can have some comfort. All right. So that first document looks like this. It's an Excel. It's the only one in there. It's called Deficiency Notice, and it's called Organization Template.
I think you might need to change your share because all we can see is the PowerPoint.
Okay. What about now?
We're good now.
Awesome. I am so glad you're here. This is what I was missing last week, is like a co-facilitator to help me out here. All right. So this is the first document that I want everyone to pull up, this deficiency notice organization. We're getting into how to organize like a lawyer. And here, the takeaways are that there are two main sections to this chart. And the way I ended up making this was I combined the missing information scoring measure chart that you all received from the DOA, those of you who are working on DOA deficiency notices right now. I combined that chart with the second chart that they have in there called reference citations. This is exactly what I would do if I was working this as a case. And then I took their instructions and I made that into its own separate checklist chart. The purpose of this method is to help you have a checklist as you review law and draft your response. And so now I'm going to go through this chart with you so you can kind of see what I'm doing here. And then next, I'll show you how I would use this chart to draft and research. All right, so we are in the chart. On the front, I have some information about what this workshop is. I have an important disclaimer, which I will say right here, which is that this is not legal advice, because that is not how legal advice works. This cannot replace working with an attorney. The purpose of this is to help you guys get equitable access to information, but this does not guarantee you results. It is to show you examples. There are many ways to approach this. Every attorney would potentially have a different way of approaching this. I'm showing you one way that I would approach this. And the way I built this is based on the fact that the law is constantly changing here. So this is a way for me to help put all information in one place that's helpful, especially when you're working on teams with multiple people and you all are trying to coordinate this together. So if I were working on this with a team of people, I would throw this on a shared drive so that we could all have access to the updates in real time. So let's start with the instructions. This part is pretty self-explanatory. This is just a way to know I better make sure I know who's assigned to each part of these instructions. And I need to know when it's getting done and have it right here in front of me so that when it's submission day, I'm ready to go. So that you're not combing through multiple emails. Keeping up with notes through email is not the most efficient or organized way to do this. And it's certainly not the way an attorney would approach it. Because as you guys are seeing, most of what an attorney does, a good deal is figuring out how to organize information. So this second chart, project status, this is the one where I was combining the information that are in the two charts that you received from the DOA. So the DOA provided you this reference citation chart and they put it separately than what your missing information chart was. So that's a little confusing, really a lot confusing. So what I did here was I said, okay, let me see what they're saying I'm missing. What are they saying is missing? And I put that in the exhibit and I corresponded it with a measure. And I put the specific legal citation. And that's something that I want to stress tonight is part of what you all may be running into is that you're not being specific in your citations and taking each part of each measure and really breaking it down in that type of way, which is why a chart like this is helpful. And you'll see when I show you the next template, why that would be helpful, how you could cut and paste and make this kind of systematic for yourself. So that is what you see here. This is me breaking it down in a way that says, okay, I know who's going to work on what, and I'm able to keep up with when we've completed what task. So this would be a much more helpful way for the DOA to give it to you, but the DOA is not necessarily trying to do the work for you. They have their own reasons for why they organize things the way they do. But for purposes of you trying to think like a lawyer and approach this process like one, I think this is one of the better ways to think about putting the information together rather than having information all over the place, particularly in emails, text messages, you're communicating with each other across all these mediums. So this is one organized checklist method. And hopefully you all could use this by just kind of cutting and pasting what's relevant to your particular deficiency process. And so now I'm going to go back to the PowerPoint and then connect this to the next tip. So here, the next thing I would do is I would take that chart that I just combined, and then I will pull up all of my original exhibits. And in this way, I'm old school. I like to say sometimes I'm an old school millennial lawyer. I use technology, but I also know how to use dial-up, which makes me very useful. So what I would do is I would print out my original exhibits. I know that's a lot of paper, but you got a lot on the line here. I would print them out and I would take each one of those exhibits and I would go through and see if I could give it a corresponding citation. And I would see then what citations are missing from that chart. And I would look and see what citations lack detailed descriptions. All right. So the purpose of this is for you to have a checklist to review the law. And I'm going to show you an example, by the way, of me kind of going through the motions right here on this live show we're doing. And then I would say, all right, am I missing one of these citations? Because that's likely what they're talking about when they say something is deficient. It just hasn't really been spelled out. And then after I did that, so now I have my exhibit, let's say A, and I see, oh, I have all of these citations and I'm missing all of these. So I would take a piece of paper. Matter of fact, let me just go ahead and go old school here. Please excuse my handwriting. I guess I'm not that old school because I didn't get the handwriting down the way I should have. So I think you can see this. And Trisha, let me know if you can. So if this was my exhibit right here, A, on one column on the side, in the margins, I would have found, meaning the citations that I found, and I would mark them. Okay, this corresponds to this. And on the other side, I would mark missing. So going back to that chart, if I were on A, measure 1, I would go through my exhibit A and I would say, oh, I see, no, I did address this first citation being right here, right? And this is how I would do it for real. I bold it so I can know I found that one. And I would mark that citation as found on my list, just like this. Found. And then I would go and let's say this second one, I didn't find this one here. And me being me, I mark it as red so that I can know red zone danger, it's missing. And I will mark the citation here as missing. And I will mark it here in red. All right, let's see how this will go moving to the next part. So now I want you guys to pull up another document that you should find in that shared drive. Give me a second to pull that one up. This is a Word document. And it is called Deficiency Notice Response Template. I provided these in Word and Excel so that you guys could make use of them as much as you possibly could and wouldn't have to be dealing with a PDF document. But we are hopefully all going to be mindful about how we widely share this information, because if you make changes to the template, it's no longer, the instructions that I'm providing. And so just be mindful of that as you share. So on this one, again, I put some instructions on the top just for context. But now I'm going to go into this one to show you how I would use this template. And before I do that, I'm just going to pop back over here to the slideshow to give you a little background here. So now I've organized all of what the DOA is saying I'm missing and what they said the citation is for that. That's where I'm at now. Now I've marked up my original exhibit and I'm seeing, okay, I found this one and I'm missing this one. And I go all the way through to the end. This is why it's helpful to have a team, because the person doing A can be super detailed doing A, B can be super detailed doing B. The next thing I'm doing is saying, all right, now it's time for me to start thinking about how I'm drafting this. And here I'm talking about how to draft a response like a lawyer. So a lawyer would use a template or more than one template that they could reuse for each response so that they're not constantly reinventing the wheel, which creates more work. In this case, watching everyone's issues, I'm noticing that there are really probably 2 template answers that are needed for everyone. Not saying there can't be others, okay? I'm just saying that what I found generally so far is I'm seeing 2 categories. I'm seeing the need to provide new information, meaning the DOA is saying you're missing something. And when you went back to your exhibit, you didn't see any missing. Or actually in this one, you did see missing. Sorry about that. You did see missing. So oh, I got to provide new information about this missing category. That's template 1. That's in that Word document. Whoa. Now I can get cocky, kind of. In template 2, you look at it and you say, I'm not missing anything. All right. But you don't want to be too cocky because they say you are missing something. So I'm going to give you some strategies for how to address that in the template. So now I'm going to go back And I am so grateful to have Trisha here because I have not really used this system of sharing documents a lot. So in the first category, we're saying they're asking me to provide new information, and I have double checked that I am missing this because I cannot find a legal citation to correspond with this required standard. All right. So here, the way I would organize it, and I want to make sure, okay, yes, I think I'm on the right screen here.
Yes, you're in the Word doc.
Okay, thank you. Thank you. So here, I would start off with my legal. When I'm dealing with an agency that has not provided me with any templates, that has not provided me with much formatting rules, I try to be very minimal in using a bunch of formatting. I try to be what we call in the legal industry conservative in my writing. And what I mean by that is I don't use a bunch of bold, all caps. I italicization. I don't italicize. I don't do any of that. I try to be as plain as possible because when someone is reviewing thousands or when they're using AI technology to review thousands of things, I don't want to give anyone or any machine reason to not be able to pick up on what I'm saying. So that's why you see on here, I'm not using a lot of bold or anything like that. But make sure you guys are following their instructions for formatting. I haven't seen any details on that. So that's how I've put this together. So I would start off right at the top, putting my legal citations and corresponding measure. And I would insert my specific citation, which I should know because I have it on my chart, in the corresponding measure. I would do the citation and measure separately for each and every one because I do believe that's where folks are starting to get caught up at. So I would separate each and every one of those. And then next, I would put my supplemental response category. And I would, again, now I'm breaking each one of these top, let's say these three here. Now I'm about to go into my narrative and break each one of those down. That's what I would do. And so I would start with my first one. So like this here is supposed to be the equivalent of my first one up here. All right, which I pulled from my Excel sheet, which I confirmed by marking up my exhibit. And then I would say at the bottom of this, attach supporting document.
Go ahead. I think that you needed to change something. I'm sorry, because I was replying to email and I missed it.
Go ahead.
So you're on the Word doc still?
Yes, I am.
Okay, but you're clicking, we only see the workshop top tips.
Oh, okay. You can't see the Word document?
It's the one that says key links. That's what we see.
Okay, no. Thank you. Let me put it on. Let me make sure.
Some of y'all are emailing me while she's talking and I can't do both.
Okay, this is the one I'm in.
Okay, now we see it move.
All right, thank you. So we're in the response one template, and this is for a situation where you are providing new information and you know that you're providing them with new information because you marked up your original exhibit and you cross-referenced it against your Excel sheet and you saw what you found, right? And you saw what was missing. And what was missing should be corresponding with what they're saying is missing in this scenario. And if that's the case, how I would do it is I would have my legal citations right at the top. All right. I bolded this just now so that you could see how I'm kind of going through drafting. But in my one that I'm submitting, I would not do that because as I mentioned, I would be careful using too many formatting things because they have AI technology helping them and human readers. And so you want to be mindful of using too much distracting formatting styles. So at the top, I would put each corresponding legal citation in measure separated 1, 2, 3, right at the top in a category that I would put on here called legal citations, letting them know I know exactly where I'm at and what I'm missing according to you. And then I would move to supplemental response as my next section. And here, I will go one by one for my narrative. So let's say this was the first one. I'm just bolding this so you can understand my flow here. This one would be the same one as that one. That's what I would put here. And right under that, I would put attached supporting documentation, and I would insert the name of that documentation. So if that was a lease agreement, I would put lease agreement 2012 to 2014, so that they can know this is what's attached to this to prove what I'm saying in this narrative. Then at the top, I would start with an opener that looks something like this. Again, you can use different language here. This is to give you an example. I would say pursuant to, according to, or based on, or under this specific legal citation. This supplemental response provides additional detail to fully comply with the requirements of the law. And then I would move into my narrative. You might notice that I'm repeating a lot. In law school, when we're teaching emerging lawyers how to write like lawyers, we tell them right from the jump, you repeat yourself a lot. The reason why is called showing your work. This is how you make sure that your reader doesn't miss a beat to what you're saying. So that's how I would move into a supplemental response for this particular type of response, where you know, because you double check, that you do need to provide them with some new supplemental information, because the old original information was indeed missing something. How do you know? Because you looked at the legal standard and then you cross-reference that against your exhibit and you couldn't find your citations. All right. The next one, the second one, this is another category that I see a lot. And in this category, folks are saying, I did provide this information. I double checked my exhibit. I checked it across. And they're telling me, don't provide them with new stuff that I already gave them. How do you deal with that? Because it's like they're talking two ways. They're telling you to give them a supplemental response. You're saying you already gave it to them. And they're saying, don't repeat yourself. This is how I would approach that scenario. Similar to the last time, I would still start off with my legal citations right at the top. I move into my supplemental response, starting with which one of these am I doing first from up here. So this one would match this one up here. Again, this could also be numbers. The reason I didn't use numbers for these is because I was concerned, because the citations themselves have so many numbers and the measures are numbered. And I try not to confuse my reader as much as possible. I try to keep things in a way to where it can flow. Now in this one, you'll see I changed the language a bit here. Now I'm saying pursuant to, according to, or based on, or under this specific law. This supplemental response describes in detail how our original application does fully comply with the requirements of the law. And this is where I will go in and I will give a narrative about where in my original application I fulfilled that legal standard. So these are the two categories that I've been seeing people trying to figure out how to grapple. Notice I'm not using redlining. That is a tactic that we use in the franchise industry, and it may get adopted in the cannabis industry here in this market. But right now I haven't been seeing that. And because they've been so adamant about don't repeat, don't give us the same thing you gave us, and it seems like that would be more confusing than helpful, instead I'm approaching answers like this. Now, keep in mind, you can combine these two methods in one response, because maybe up here, this first one, you saw it was missing. So you're going to use a narrative that looks more like this section, right? But then you look at the second one and you see that wasn't missing. So you're going to use a narrative template that looks more like this. Let me describe to you how we did tell you this. It is okay to tell them that you told them. They asked for a supplemental response. The new information here is pointing out, I told you. I told you here, here, and here. I'm not saying be snotty about it or unprofessional. Very professional. Here's where I comply. Page this, exhibit here, you know. So that is how I would approach this. And I think this is really kind of coming to the end of me sort of sharing the information, Trisha. And I would just end with a couple of final tips before we break open to Q&A. And that would be, first, to plan to submit at I say 12 to 24 hours early, to give you time to deal with tech issues, because they come up a lot these days. Next, take an inventory and spread the work out. Use your full team. Everybody's got to carry buckets. Everybody that's got 2 hands needs to carry a bucket on this. This is a lot of work, as you can see. Prepare to use FOIA to request information immediately. Now, if I were approaching this, I would have been requested some FOIAs way earlier before they ever sent me a deficiency notice, right? But it's okay, it's not too late. What I would have sent them beforehand would have been, please send me copies of your appeals process. Please send me copies of your rules and regulations, so that I can make sure that I'm working with the same information that they're working with. Now you can still do that on the back end. Keep in mind that many aspects of the licensing application process are under current litigation and legislation, unfortunately. So that means that there are going to be changes to come. There may be things that you're giving answers to now that are categories that are deemed by the court to be unlawful, or areas that the legislation negotiates and decides to remove. So just keep that in mind. Stay the course and be kind to yourself. Be very kind to yourself, because this is very hard work. Trisha, if you don't mind, I really like to take about a 3-minute break before I hop into questions, just for a refresher, if that's okay.
That's fine with me. I can talk for 3 minutes.
Okay. All right. And then I'll come back and
Okay.
I'll be ready to take questions and all of that good stuff.
Okay.
Okay.
So for those of you who have questions still, please feel free to type them in the chat. If you have, so for those of you who missed me saying this earlier, hold on, let me turn my camera on, put my glasses down, because I was looking at my phone and I can't see the phone with the glasses on. Okay. This presentation, the recording, will be up on our Dropbox. I will send that link out. It's the same link I've sent for a Dropbox many times before. So I'm just going to add this there. When I send the email out, I will also email everybody the link to the documents if you didn't already get it, but it's in the chat. So you should just be able to scroll up in the chat and get it. And I'll say I am very happy, because this is good stuff. Very, very organized. Even in the work that I've done to try to support you guys, when I've looked at people's deficiency notices, you would not believe the number of windows I have open, going back and forth between laws and everything. So very, very helpful. I know you guys are finding this very informative and helpful, as have I. What else did I want to say? I know that there was some of you may have heard that there's a competing webinar tonight. I did get a link this morning with a coupon code for you to go and review the video for free. I'll send that out later. I hadn't had time to even send that today. So I will send that out later, and I was not going to promote a competing webinar. But I will send that later. If you want to, let me go ahead and share the link to my calendar. I'll do that now. I'll send it again later in email, although I'll say there's not that many slots left. So if you still feel like you want a one-on-one with me, you can book that. And obviously, you know that your deadline is 11:59 p.m. on Friday. That is the last time to submit. But like SL said, try to submit early, because there will be tech issues. And I have talked to people who in the prior round of deficiency notices never got confirmation or anything, and they submitted, and now they've got a notice of disqualification because the state is saying that they don't have their stuff. So let me go and grab my calendar link. And I will send that to everyone. That is the link to my calendar for you to be able to book a spot. And let me pull up the Q&A. So I'm going to say, even though this is not my purview, I'm going to say this anyway. It's really important that you read the citation. I just got done emailing someone about their SEA deficiency notice. And this particular person, I don't know if they're on the call or not. Let me look. No, they're not. But this particular person qualifies as an SEA because of arrest record. Are there any examples of financial plans from prior presentations? Autumn, I'm not sure what you mean. We provided tools during the application process that would help with the financials. It wasn't necessarily a financial plan. But let me go back to what I was saying, especially since SL is here, so she can chime in on this, because I think this is going to help everybody with their deficiency notices. I always say I'm not a lawyer, but I play one on TV. I used to that was the job I wanted, and then I got tired of school. So, but that was my thing growing up, because I'm very, very meticulous about details. So here's what I'm saying to everybody. Read the reference citation in detail. And here's some of the things that I've done when I've looked at, some of you all have sent me your stuff. I'm not saying everybody sent me their stuff, because there's only one me. But I've read through them in detail. I would read the reference citation, and then I would look at it as if it was a checklist. And I would look for specific keywords. Because we know that, for example, with the SEA deficiencies, one of the things that has gotten people caught up is they didn't sign their tax return. We know this to be true. I had another attorney, the one who filed the lawsuit against the state, he told me this: oh yeah, the cure is a signature. If they're that much of a stickler about a document that they know that they have, and you just basically provided a copy of it, all it needed was your John Hancock on page 2, then you have to treat every word in that reference citation as if it was a checklist. So here are a couple of examples of things that I've seen. One, I was just emailing, that's why I missed when you switched it, I didn't see it, because someone has sent me their Exhibit G, which was their social equity applicant, and they even had an attorney. They sent me their Exhibit G. Their reason for being social equity is because of their arrest record. They had, and the relationships, if it's dependent or parent or whatever. They had all of that information. They had copies of the arrest record. They had marriage licenses, all of that. But if you go back and you read, and I sent them an email, if you read 1300.300C33, subsection A says, Illinois residency. And then it gives all the ways that you can prove Illinois residency. Then under subsection A are 3 subsections. It's Roman numeral, little I, double I, and triple I, which give you either you live in a DIA, you had an arrest, or you have 51% of your employees. Then you have to provide proof of that. Those are 2 different things. So if you did not include the residency part, then the rest of the stuff doesn't count. You have to have both.
Yes.
And another example that I've seen, there are a few examples that I've seen. So I'm gonna tell you some common ones, especially since there's a bunch of you all here right now. I'm gonna tell you some common ones that I've seen as I've reviewed. Let me get my notes out real quick. If you have a cultivation, so I know this doesn't apply to everybody. In the labeling, yeah, the labeling plan, there is, go focus on 1300.930D. It has A, C, and D. I want you to read D, because D talks about if you are creating products based on concentrate or different processes, then it tells you what labeling you have to provide and what type of extraction process was used. It is in a different part of the rules than the previous stuff about the labeling. So if you follow the previous rules and figured, okay, I got everything I needed for labeling, you might have missed that if you plan to use any type of extraction methods. So if you didn't have that, that's probably the piece that's missing. Another common one that I have seen, y'all see I have notes. Hold on, I can't see the notes. In your business plan, make sure you talk about how you're going, DIA economic empowerment. That is in 1300.300 C10. And then also your experience in cultivation or horticulture. That's C11. In your record keeping, I was looking for keywords. In certain areas, I'm looking for keywords. There were keywords like, in your record keeping, it says, you got to have record of all transactions, but the record keeping says very specific things like price. I look for the keyword price because I guarantee you that's what AI is going to do.
Trisha, that's a not to interrupt you, but just to like seriously affirm you, that's another tactic that I would be using on my kind of going through my markup.
Mm-hmm.
I'm not finding the words. This in law, there is no reason to change certain words.
That's
so
right.
When it comes to the statutory stuff, do not change the language. Use the exact language. I don't care if it feels like you are repeating yourself until you are blue in the face. Repeat yourself. That is the goal here. That's the instruction, is to repeat yourself. So for every measure and every subsection, as Trisha is saying, use the same keywords in there in your description of your supplemental answer. At this point, we should all presume there is AI working with everyone. And it is big in the legal industry right now. It is one of the fastest growing technologies in law right now.
There you go. You heard it. You heard it here from the lawyer. So let me go ahead and get into questions because I got on my soapbox for a while.
That was a good soapbox, girl. That was I was over here like if I had a tambourine. Because really though, read the instructions.
Yes.
And even if you're working on, one thing I want to say about the stuff you talked about on your soapbox, when you're working with a team, understand that at the end of the day, you are still ultimately responsible for these things, you and your team, because it's your money and your investment and your dream on the line. Even when you're working with attorneys, even when you're working with consultants. And one of the things I am thinking about doing a future workshop on, at least for novices, is this idea of how do you best work with the different players and stakeholders? Because attorneys are good for one particular thing, but they are not good for all things in this process. And business consultants are good for particular things, but they are not attorneys. It's a reason why we got an ESQ and they got an MBA.
That's
we do different things.
That's right.
We're not in competition with each other. We're in complement to each other. So, but you do sometimes see folks trying to wear both hats. And I think it's creating a lot of confusion in the cannabis industry because you need to use the lawyers to do law things. You need to use the business consultants to do one thing. And you need to use the lobbyists to do another thing. And so just really keep in mind who all these players are and how they can best serve you and how to leverage those relationships.
Absolutely. Yes. Yes. I'm like, because even though I have the MBA, I can put on a lawyer hat, but don't actually ask me for advice because I can't tell you what to do. I can tell you what makes logical sense. And then I'm going to go check with the attorneys to see if this makes sense. When I first started getting questions on Tuesday or Wednesday, I emailed multiple attorneys. What do you think? What do you think? What do you think? I compared the answers from those attorneys as well because everybody interprets the law differently. We know that from court cases, any Supreme Court case. They do not always agree.
That's right.
So get as many opinions as you can. But basically, you got to be able to inform yourself enough to form your own opinion, and you validate that with some person that's a little bit more educated than you.
Trust and verify.
That's right. That's how I live my life.
Same.
Okay.
That's why we might be kindred sisters.
Yes, we are. All right. So first question. Can bank statements be used for proof of address of a social equity document?
So as I answer questions, some of them I'm going to use as examples of how I'd be approaching this as a lawyer, if that's okay, because I think it's a good learning exercise. So the thing I would do first here is I will pull up this FAQ if you guys have not seen it.
Yes.
That's the first thing I will pull up. And this would be, girl, I'm still getting used to the screen share. Bear with me, y'all.
I might have it open.
Here we go.
Okay, you got it.
Do I have it up?
Yes.
All right. First question on here, evidence of residency. And I would just take a quick little peek through here of what kind of documents they're saying. And because they tell you where they talk about it in the act. So I would pull this up too. And I would see, okay, signed lease, a property deed, school records, voter registration, driver's license, paycheck stub. Okay, if they willing to take a paycheck stub, tax records, financial record, they are more than likely willing to take your bank statement. But be cautious about that and look at the act, right? These aren't things, I'm gonna tell you right now, no attorney is gonna know these types of answers off the top of their head. What attorneys know how, and if they do, you be careful taking it, taking that advice, because this law is particularly this area of law, just like franchise, why I love them both, is they change a lot. All right, so they keep me employed. And what you really know how to do as an attorney is you know how to find information. So I will go pull up this app and see, like Trisha is saying, I will control find and see, do I see bank statement, bank record in there? If I don't see it, I would try to contact the agency and ask them, will they take it? But I will caution on the side of giving it to them, because if that's all I got, that's all I got. And I would say that I would have a pretty strong argument that it is reasonable for me to give them that and that it does conform with the law. And I would probably say this in my response. I would say, noticeably, under this section, you accept financial records that include tax records, pay stubs, blah, blah, blah. Therefore, this falls within that same category of documents, see attached. And I would also delete my account information because, be safe out here. I would not give a state agency or anyone my bank record without redacting my account numbers and such, even for closed accounts.
Good information. That's a good thing there. And I'm actually looking at 1-10 right now. And that list that they have in the FAQs pretty much matches this list. But I also want to point out that one of the things that was in the FAQ was that they gave another detail that said you can combine the two things to create the 5 years that you need.
Yes, you can.
Which they did not state before.
Right.
So
they are making things up as they go because it's new. But I want you guys to feel empowered by that. Because what that means is you got a lot of arguments about whether they're acting arbitrary or capricious.
Right.
All right. In terms of like, hold on, now, is this fair? Because if you allow this and you're making it up as you go, why can't you allow bank records? So go ahead and attach those bank records along with whatever other kind of record. But what I would try to do is find a citation that's very similar and say, similar to this law, I'm providing this because this is what I have. Okay, so I'm typing and sending that answer. Okay, so Michael said, thank you.
think we've already, so I can dismiss that one. Okay, so the next question, which I think we've already answered because this was typed at 6:02.
Okay.
So how are we to format the deficiency responses? Our wonderful attorney SL Owens has already given us the format. So, and we have that document and everybody has that link by measure, by citation. So we know that that's been answered.
Yes, and as a caution, those links will work probably for like 90 days because I'm usually needing to update things as the laws change. So just, keep that in mind.
Okay, next question is zoning. If you don't have zoning approved yet, but have a location, and what are the repercussions? I believe that was actually answered and it's on the department's website.
It's on the FAQ as well.
Okay.
So where did they put? I think they put it on the FAQ, and I know I saw it on the website as well. Give me a second. You guys are seeing in real time how I would be working this. So right now what I'm doing is I'm looking at the FAQ to see what they say about zoning. And this is why I said some of these I'll be able to answer in real time and others I may have to answer later because it may require a little bit more digging, but let's see what I can find in real time here. Now, just so you know, number 9, Trisha, on the FAQ talks about changing locations.
Okay.
If you no longer have access, but I don't see.
And I believe I'm going to pull, okay, I have it saved. So let me pull up. Okay. Department of Ag.
Yeah,
because I think it was in a previous. Oh wait, where did my link go?
And yeah, you're right. They have the FAQs there as well.
Mm-hmm.
So I've just gotten to their website. Let me know if you want me to drop the link for you.
No, I found it. I'm thinking of what the term is. I want to look for zoning. Search for that. No, see, there's only 2. It was up here before.
Yes, it was, and they might be changing this some. So sometimes when
they
stuff, it's because they're changing. So I think, can you save that question because we have an email where we can ask these questions?
Yes. So I will save that one.
Okay.
Because this, I know it was there because I remember sending an email about this previously.
Yeah, I've looked at that too, but I haven't looked at it in a while and I don't see it on there anymore.
Mm-hmm. It was on the website before. I might have to go back through my old emails that I've sent to everybody and see what they said because I might have sent that FAQ somewhere. And I know the FAQs are hard to find.
Yeah, they are. That's why I don't even.
Oh, you know what? It's probably in that the is this it? Hold on. Deficiency notice process. No, they changed that.
No, it looks different. That's why I don't even save the link anymore because sometimes it doesn't work anymore.
Okay, so I'll come back to that. All right. So when you talk on the next one, I'll keep searching.
Okay.
All right. The next question is, I received a deficiency for Exhibit C, Measure 3, AIAC 1300-307A3. The citation reads almost exactly like the criteria listed for Exhibit C in the application. Does that mean we need to resubmit the entire Exhibit C?
So once again, I'm going to go back to how I said I would approach a category. Well, number one, I would first double check because I've been hearing a lot of folks claim they've done something that when I ask them to do their scratch work, I'm not saying that's you. All right. I'm just saying I see. And I'm saying that oftentimes when they do their scratch work, like in math, when you class, you have to show your work. The way to show your work here is to pull up that Exhibit C and go through it with that citation and see what do you see found and missing, and go ahead and use the search term method that Trisha and I talked about tonight. And if you don't see that, then you might not have gotten everything that you think that you already submitted. So that's number one. And if you see it missing, I recommend that you use that document template called Deficiency Notice Response Template. And the one with missing was was it the first one? The first one. Yes, template 1. And I would go through what's missing by measure, and I would provide detail. Now, perhaps you might find yourself in a situation where it's there, but it's not meaty. You didn't give them the gravy and the potatoes and the meatloaf. All right. You just gave them maybe the meatloaf, and you didn't give them potatoes. And what I mean by that is you addressed it, but real cavalier. You didn't really sort of flesh it out. That could be another way that you can supplement your answer and provide new detail. So no, don't just go giving your whole old exhibit, because your old exhibit is not going to get you any new points. You need to give them new supplemental answers.
There you go. And a new supplemental answer, as you said earlier, might say, per this section, I provided this. Yes.
I provided this here. Tell them where you provided it in your application. Feel free to quote that section of your application, because the new information is giving them the context in the citation to where you did it. But just giving them the old exhibit, it's not going to advance you.
Okay. All right. If something was included in your original, this is a good question. I've seen this a lot. If something was included in your original submission but not cited, how should you draft your response to reflect that?
Yes. So I would, let me pull up my example and see how I would tweak it. Give me a second, because that's what you do. That's why we make these templates as lawyers, because we're not starting from scratch, baby. Hold on. So give me a second here, guys. So you're saying a situation where you gave it, but you forgot to give the exact citation. Okay. I would use, so I would still use the one that's number 2, template 2, where I'm saying pursuant to, according to, or based on. So this citation, now you're giving them the citation. This supplemental response provides additional detail to fully comply. And then in the description, Trisha, I'm going to do a screen share real quick.
Okay, go ahead.
Look, I'm going to try. Here we go. All right. So I am now back in, nope. I want to be here. Example 2. So this is, I will consider this question to fall under clarifying information. The clarifying information being that you didn't provide the citation, and that's how they ended up overlooking your answer. And so I would go down here where I put pursuant to, according to, based on, under. It's lots of versions of this legal citation. Now you're providing them the legal citation. This supplemental response describes in detail how our original application does fully comply with the requirements of the law. You can still use that. But down here in your narrative is where you say, where you discuss this and how the legal citation that corresponds to it is this. Okay?
Girl, that's good stuff.
Hey.
I feel like I need to pay an offering. Okay. Okay, so I'm about to send that answer. Okay. Would you recommend citing in the narrative, or is it sufficient to just cite at the top? So I think that's already been answered in the last answer. Cite in the narrative and at the top.
That's right. Show your work. And the top is to give them what we call in law a header. All right, we like to give our headers because that's a roadmap for our reader. Lets them know, I know what I'm talking about. It makes them feel, it orients them into your persuasiveness, because it tells them, oh, this person knows what they're talking about. Right? That's what the header is for. The narrative is to flesh out the header and go ahead and use that citation, because these citations, even the little individual ones, still sometimes have little pieces to it. It might say price, product, I'm making this up, but measurement. Well, you want to make sure you hit price product measurement.
Yes.
Use every key word and every law in every subsection and every measure.
Yep. All right, next question. The use of citations in your first submissions, did you have to cite all the laws and statutes in your original submission?
They didn't give you guys any instructions on
Right.
that. All right. So no beating ourselves up about what we didn't do. All we gonna do now is do what we can do. Don't worry about that because that was not in their instructions. Now though, you want to get ahead and get into that.
Because SL just gave us instructions.
Yes. If you are not a lawyer the first round, you wouldn't have done that. If you are not
Right.
a lawyer who did not already practice cannabis law in an established jurisdiction, you wouldn't have caught that either. You
Right.
guys have to remember that I come from the oldest legalized market. Even though this is my hometown, my other license was in Colorado before I came back here. I retired that license because, hey, I'm in the new school now.
Right.
You're paying all those fees. But that's why I know so much about the industry and what they're probably going to do next and what they should have done and how to anticipate.
Okay, so the next thing, okay, I think there's a question and here's a lot that said. So thank you so much to both of you for providing this insightful information. This has been the best SEA webinar resource I have experienced to date. Real information and not a fish to see something. Thank you, thank you, thank you. I want to make sure I am following to confirm. If you were responding, would you put all of your citations up top and then at the bottom, keep stacking each supplementary response for those citations? Or would you use the entire template per each individual citation?
I would use the template per exhibit. So want to make sure we're all on the same page about that. So this, hold on here. Give me a second to pull it back up.
That's actually a really good question. I'm
It
glad
is.
you
It's
asked
a
that.
very good question. And it's just always easier for me to show this stuff because it also helps me not slip into legal jargon. All right. So am I showing response template now?
Yes, you are.
Okay, perfect. So you will notice here at the top right here, it says exhibit blank exhibit title because I will create one of these for every exhibit, which if you look at the instructions, I'm almost sure they want separate files for each one of these. I'm not making that up right
Nope.
now. Okay.
Nope.
So this top right here is to tell them at the top a roadmap of all of the specific measure and citations that you're going to do for exhibit A. That means all of the things that they said were deficient. That's what I'm putting here at the top. I know it's about to look repetitive, but trust me. I want you to trust my experience and I want you to trust my education. All right. You need to do this. So you're going to put this up here at the top so that they know this is where I'm at. All right. The other reason I have you doing this to show your work is so that you can fight in the back if you have to. I want you to not have to fight later, but if you have to fight about this later, you want a reviewer or an arbiter or a judge or an appellate body to be able to easily follow what your work was. Okay, so this is not just for the application process, but this is also to help you with a potential appeals process. Okay, so you're going to put your legal citations up here because any lawyer that's looking at this later or a judge, they're going to love you for this because they can follow. Okay, they're clerks. They'll say this is organized. I see what you mean. You're right. They're wrong. I don't know, but hopefully I still say. So you put all of them here for exhibit A. Then you move down to your supplemental response. Here, I want you to do separate sections like this for each one of these. Okay, so
Yeah.
I will take this first one and I would put that here. And I would put my attached documents and I would do my opener header and I would persuade my little life away right here. And then I move down and now I'm on my second one. I'm using colors to kind of help you guys. And I say, all right, next. And do the same thing here and so forth. All of Exhibit A's deficiencies all being in one file. Let me double check that across the instructions,
Okay.
which is another reason why I like to put them like this, because I just want to make sure they're not always as clear as we want them to be. But I could have sworn they had a whole one file theory going here. Oh, matter of fact, that's in the FAQ. That's where I read that. Because these are some of the little things that people mess up on.
Mm-hmm.
How to submit. Okay. Each supplemental response should be a single file. So let me make sure we all on the same page here, because these are the things that separate the winners and the losers. So that's why I'm being so meticulous about this. All right. Here I am now on the FAQs. Recently, I'm on number 12. Should supporting documentation be included with the supplemental response for a given exhibit? Each supplemental response should be a single file and should include any supporting documentation and responses on all deficient measures. So that is why I have this organized like this. I knew I didn't just like make that up out of out of thin air. So that is why it looks like that, you all. That's why I have you doing one exhibit for A, doing every deficient measure, and having you attach the supplemental attachments that you want to put, make that all one file.
There you go. Okay, so let me send that. And I'm still, and FYI, you all, I'm still looking, because I've been sending you guys emails all along. I'm still trying to find the old email where I copied from the Department of Ag site on the zoning. So I'm actually, while we talking, I'm searching in my email at the same time.
Okay, I appreciate that, because I don't have it anymore. I know that.
So next question is, should we complete the survey prior to submitting the supplemental responses?
Well, I would say yes if I were doing this, because I would love to give them what's required before what I give them is what I give that's optional. That's how we do triage in the emergency room of law.
Okay. Is there a link to request FOIAs?
No, you may find some out there on Google. I'm gonna do a workshop on it where I can put together some templates. I have that on my list back here. Trisha and I are going to reconvene after this.
Yes, we are.
Some future stuff. So
yes.
But I do have FOIA on there. Right now, you would probably be best finding like just on Google, maybe Illinois Legal Aid might have some stuff out there. Just be discerning when you're looking at Google. Be discerning, like Google is Google. Google is not a lawyer. And so I'm here because I work for a public law school, UIC, whoop, whoop, the only public law school in Chicago by virtue of a merger between John Marshall Law School and UIC, which allows the public to benefit from the resources of the university. So that is why you all have access to a skilled regulatory attorney.
Awesome. Okay. Just to confirm, as a craft grower, to receive the points awarded for Exhibit H, which is labor employment practices. Okay. Were we required to submit a signed and notarized labor peace agreement, or just state a plan to?
I'm not going to know that off the top of my head. I would have to look at the corresponding statute and measure, which they should have given you.
So, and here's what I'm going to say, because I've looked at some of these. So here's why I think that some people might have not gotten it if you only submitted your labor peace agreement. One, if you read the definition, let me look at Exhibit H. And so if you go and read 705 so this 410 ILCS 705/1-10 definition of labor peace agreement. It has in that definition the terms of agreement. The labor peace agreement that you got from whatever union that you signed it with doesn't actually express the terms of agreement that are in the definition. Some of those terms, as a matter of fact, hold on, because I have all that stuff open.
Oh, that's perfect. Look at this. See, this is why this tag team is. I don't have that open.
705/1.
While she's pulling that up, I want to go ahead and affirm. Notice how those are key terms that you need to repeat in your response and then describe.
Mm-hmm. Okay, so let me share my screen. So now here is the text. Here's where labor peace agreement starts, right? And it defines what it is and what it does, blah, blah, blah. Now, this is the part where I think people have gotten caught up. I'm not an attorney. I just read it, but I'm very detailed. Mm-hmm. This agreement means the cannabis business establishment has agreed. So this is, to me, a sentence that says, my business is agreeing to, bullet point right here, not to disrupt efforts by the labor organization to communicate with, attempt to organize, and represent the cannabis, to represent our employees. I shall provide them with access. Here we go. Provide the organization with access at reasonable times to areas in which the employees work, so in my business, for purposes of meeting with the employees to discuss their rights to representation, employment rights under the state law, and terms and conditions of employment. Those are very specific things that you are agreeing to by signing the agreement. But if it were me, I would be saying, this agreement means I've agreed to this. Right. These are the words.
That's right. And feel free, if you want to add some flavor to it, to have a notary and affirm it in an affidavit. My favorite little,
there you go,
that I have sworn to something.
And then you back it up with the labor peace agreement that you had already signed and already provided.
That's right.
Oh, does SL take private clients?
I am retired from private practice right now. So no, I don't take private clients. I only take public interest cases at the moment. You guys missed me by about 60 days. I closed my last private case in the fall. So right now, wow, in order to work with me, you would need to apply to our clinic for legal representation. And that's a one way to work with me as your counsel with my students, with my law students as a case. And then another good way, I'm hoping to really make these types of workshops a way to really create broad access to legal information. So as some of you know, I am open to taking suggested topics. So you can always send me some suggested topics that you would like to see. I can't promise when, how, because as I said in my last workshop, one of the rules, like an actual rule of law of being a lawyer, is that you are to make yourself competent in things that you discuss. And so I would probably need time to make myself competent in certain things depending on what you all are asking to see.
I actually have a follow-up question, which is, does a person need to be in the Chicagoland area to apply for representation through JLMS?
No, thank you, Trisha. That is an excellent question. You need to be in Illinois to apply to the JMLS because we are training law students who are working under a supervisory license, y'all. When it gets a little close to 8, like, I'm gonna start slurring. This is a sports drink, okay? I want to be clear that I'm slurring because it's getting late for me. But so you just need to be in Illinois here because our students are working under a supervisory license through the Supreme Court here to be supervised by Illinois barred attorneys. So we're not representing out of state clients.
Awesome. Good to know. That's for me to file in my back pocket. But also because everybody, I know all of these people aren't necessarily in Chicagoland.
Which is why I was so excited to be here tonight, because I know that you have broad reach across the state. And you are based in Danville.
Yes, yeah, yes, I am.
My husband and I did a tour of our ancestral history in Illinois and stopped in Danville along the way over last summer. So,
Oh, wow. Okay. We got to talk. Okay. All right. So I'll move on because we've got a few questions left. Because
okay.
I feel like SL and I go get together and have some virtual wine or something one day.
Yes.
Okay. So, FOIA. I'm glad you asked this question, Yashika, because this was on the back of my mind. How do you request a FOIA? I've tried and was told I'm not qualified to get any information. And am I allowed to get information that doesn't belong to me? And I'm going to give just one little tidbit that she didn't say. She asked for her own, for the dispensary round, they asked for their own stuff and were also denied.
Right. So the first thing I'm going to say is that I know about that because every request is different under FOIA. Every agency's process is different, and how they apply FOIA is different. So what I mean by that is a lot of this is case by case and will require some actual analysis. But what I can tell you about what I have observed so far from a distance is that when you are in the middle of a competitive process with the state, whether that be a bid or a licensing process, during that process, they, meaning many of the state agencies, like to claim an exemption that has to do with the competitive process, right? Because you're in the middle of it. So that's sort of the exemption that they like to claim during that time. Now, I want you guys to make sure you understand the difference between that FOIA bucket that I showed you and state records bucket and that due process bucket. All right. So FOIA is one way to get information, but also your due process rights might be another claim to why you want certain information so that you can understand your appellate rights. So some of the things that you could be saying to them as you self-advocate, and unfortunately, I'm just going to say it straight. Sometimes you really just need the face of a lawyer to help you with some of this. It's true. And for some of the teams, I would say that you all may need to start pooling together your resources to just have an attorney that could do some of the stuff for you. You know, some stuff you might be able to come to these workshops for. Some stuff you may be able to apply for the clinic for. But keep in mind with the clinic, we're working with students on a timeline that has to do with the semesters. So we're not churning out casework like I did when I was in private practice, which is why it's going to be hard for y'all to convince me to come back into private practice. But for those lawyers that are in private practice, there are lawyers that do FOIA all the time. So you may really want to consider, because what lawyers add is a bit of teeth to those requests, right? So you don't just get handled any kind of way when you show up with your ESQ. They sort of sit up straight and they process things with a certain level of seriousness, is what I should say. So just keep in mind when you're asking for your score, they may be rightfully saying no under FOIA because you're in the middle of a competitive process. And that may give you a disadvantage, particularly if they have not disclosed that to everyone. Okay. And the process is still in the middle. I want to say maybe they might be right. Notice, I'm not saying they are because I don't know, because I'm not up close on that case. But you may have a right to it through the due process bucket because you're trying to understand what your rights and remedies are. So just keep that in
mind. Okay. Next question is, do we know if all applicants received deficiency notices or were some applications rejected outright? I think we know that some people got rejected or disqualified. I know that for a fact because I heard from one. Okay. And it could be because the one that I heard from was because they were in the previous, there were earlier deficiency notices. They responded, or at least they thought they responded. they never actually got a confirmation that their response was received. And now they've gotten a notification of disqualification because they never responded previously. And what I advise that person to do is get an attorney.
That's not a process issue, especially
Mhm.
because there's no appeals process here, you guys. So when mistakes happen, who's the checks and balance to
Right.
make sure that mistakes aren't happening? And these mistakes are high stake.
Mhm. And extremely expensive.
Mhm.
So I don't know if we know if all applications, you know, if everyone got deficiency notices. I think the only people who would know that are the people who are doing the scoring, and
But
maybe the governor's office.
if you're on this call and you didn't get one and you feel antsy about whether you should have gotten one, I wouldn't wait to find out that I got disqualified. I would be proactive and I would contact them to say, my understanding is there is a round of deficiency notices. Can you confirm for me that I am not, that I don't qualify for one? I would ask. I'm not saying that they're going to give you anything, but what I'm saying is I would start to have a paper trail of me trying to access my due process.
Mm-hmm. Because it's all about what you can prove.
That's right.
Okay, next question is, okay, so the citation is asking for the, I think this is a follow-up to something that was brought up earlier. The citation is asking for entire Exhibit C, IAC 1300.307A3. So, I would say that may be your interpretation of it, but it's really about reading those fine details of that particular exhibit. And if this is a craft grower, then you're talking about your security and record keeping. And I would say if you're looking at, so here's the thing, 307A3 is mentioned in Measure 1, Measure 2, and Measure 3. So it's really about looking at the details and the specific words that are in that exhibit. I'm gonna go back to what we said earlier. Do a keyword search. Look at those, look at that. You have to read that paragraph as if it's a checklist and search for those keywords. And unless you cited the citation verbatim, which sometimes people didn't because people are like, I'm supposed to write my own plan, then you might have missed a keyword. And if you're missing that keyword and the AI didn't find the keyword, now you have a deficiency. So if that's not the answer to your question, if that's not what you meant, please type in the question. You have anything to add, SM?
No, that was
Okay.
perfect.
Okay. If you were deficient in the admin code, but not in the CRTA code, would you recommend bringing it up, that corresponding regulation in the supplemental narrative as well, or stick to only referencing the one citation?
Hold on. So they're saying they were deficient in maybe the regulation, the implementing regulation, but not under the CRTA?
I'm thinking that they meant that they're deficient in the law, but not the rule.
Okay. Okay. Yes.
That's what I thought they meant.
Okay. So if what you're saying is that, I'm going to further distill that to say that your deficiency notice pointed to one citation and not the other citation. And I would focus on the citations that they gave me. Now, feel free because they make mistakes. That's why we need an appeals process. If y'all ain't know this, I got my own soapbox of issues I want to see happen here. But, you know, they make mistakes. So feel free to pull your exhibit up and look at both so that you can make sure you are catching what you're supposed to be catching, just in case they miss something. But your focus here really needs to be the things that they're pointing out to you, because you have a paper trail of them telling you that's what was deficient.
Okay. Next question, when the deficiency includes duplicate citations, do you respond to each citation, even if it is asking for the same information? For example, this is an actual good example. ILCS 705-35-10A9 is the same as 8 ISC 1300.400D9.
Yeah. I had to go Austin real quick with that. I'm sorry. I got
because the law and the rules, and SL, I do understand a little bit about law. I worked at CCH for 13 years.
Okay.
So I understand the law. So the law and the rules, in many cases, especially in here, it's the exact same wording.
That's right.
Both.
I would, because I'm breaking it down to them, because I'm showing my work, because I have a checklist. I would not presume I covered it when I talked about one citation. It is okay to repeat yourself, because what's new is the new citation.
Yep. All right, next question is, sorry, when you say one file, is that different page per supplement?
No, that's one file.
For the entire exhibit?
For the entire exhibit, yes.
Do you know if any transporters have been scored, or any of the licenses? So I believe everyone is in the same point in the process right now. They've not issued any scores or anything like that, Pam. They're just getting everyone up to par so that they can score.
Right. My understanding is that they have reviewed certain aspects of it from just looking at the FAQ, and that they plan on sending more, possibly sending more deficiency notices as they work their way through. And they're not going to score until they have all of the deficiency process done, is what it appears that they're doing right now. Notice all those qualifications.
I'm typing, so I can't talk and type at the same time.
I understand. Take your time.
Okay, next question is, in your example, you show the specific citation. Should we also include all the law under that citation, or just the citation?
The specific citation that they give you. My examples are using specific citations from the DOA, from actual deficiency notices from the DOA.
Okay, so some are saying they have received 75 already. 75 what, Pam? I think we need clarification on this one.
Okay.
Yep, so. All right, next question is, for instances like deficiency for Exhibit E labeling plan that reference something in the code that is part of the license scoring application, 8 IAC license application, cultivation, processing, inventory, and packaging plan. Should we address all the plans for the specific exhibit, or just the plan like packaging plan that applies to this specific exhibit?
I will be going by the citations that they provide, not by the general laws that relate to a specific exhibit, if that makes any sense. We're not working backwards we're working forward from the specific citations they put as being deficient, also known as missing, in that missing information chart. That's where we're working from. We were during the original application, we were working from the whole process. Now we're down to the nitty gritty of what they're claiming is missing.
Okay, so I think, okay, the rest is, I think we might be almost done here. Okay, so thank you very much, ladies. This has been a fantastic webinar. You've been very informative and helpful. I'm mad that I didn't get a chance to type up a survey yet. You all make sure that when I send the survey out, that you answer the survey, because those go to the state. It makes us both look good.
Well, hold on, even more than that, it helps me and her be here.
That's right.
Like what you see tonight.
Right.
You tell us, not just in these chat boxes, which I appreciate because I love my roses now. You need to more so tell us in that survey, because
Yes.
how the state justifies funding having a regulatory attorney here for you and having
Mm-hmm.
an experienced business coach and consultant like Trisha here.
Yes. So let's see what else we got. Okay, so Pam is saying that their consultant is telling us that she has a client who has received a perfect score. I didn't think that was the case, just checking to see what you all know. I've not heard that anybody has gotten a score yet. So it could be that she's presuming they have a perfect score because they haven't got a deficiency notice yet.
Right.
But we also know, based on what they put out in the FAQs, they haven't finished going through everything and sending out all the deficiency notices.
They're just getting started, you guys.
Yep. So yeah, we don't know anything definitively on scores. And I'll also say this, especially since it's a number of people here, we never hear a heads up from the state on anything. So when you all got deficiency notices, we found out because you contacted us. We wish we had gotten a heads up.
Of course, because we would have done this presentation weeks ago.
Yep.
And we will continue to advocate to get more information. But you know how you can help us advocate? By filling out those surveys,
Mm-hmm.
putting that type of stuff in there. This is great.
Mm-hmm.
Here's some things I would like to see. Because those surveys matter because you're the constituents to the state.
That's
They're
right.
tax dollars from the constituents on this
Right.
type of service.
That's
So
right.
that is how you give us leverage to go in those rooms when they invite us in those rooms, and they do, to say, this is what we really need. You love what you see the Trek School doing and John Marshall Law School doing. We could do more if we're given more access in this way.
Yep. And I would also add to that, also call your state rep and your state senator and tell them, because they will call the agency heads and they will call the governor's office and they will advocate for changes that need to be made.
They will. And they're in the process of legislation season.
Yep.
This is the season. I know y'all busy. I know y'all tired, but this is the season if you want to see change. And you all can actually possibly see it manifest during your process.
Yep.
Because they're making changes during these processes.
Yep. They're making them right now. Okay. So then there's a specific question about a specific law asking, is it speaking of cannabis waste or trash waste? And I think the answer is we'd have to read the detail of the law to know specifically what it's asking.
You all need to read, when you're reading these specific citations, it's okay to look at the broader section, understand the specific citation. So I'm not telling you to ignore all the context and other lines and subparts around it. What I'm telling you is use that as the context to understand, but only focus on answering the specific citation.
Yep. Now I'm like a dog with a bone. I'm still trying to find that email I sent. I'm gonna check my cannabis emails because I'm like, I know I sent this. And you all know that I will sometimes copy from the Department of Ag's website or give an overview of what it said on the website. So I know I sent it because I remember sending it. So give me about 5 minutes from me. And I am going to see if I can find. Okay, insight on licenses, is this it? No, that's not it.
Someone just popped in Andre.
Another question?
No, not another question, a link that they say we might be looking for on the zoning section, the old FAQ link.
Okay, let me come back.
They popped it in the Q&A. I know these questions were growing like weeds. I thought they were here overnight.
Okay, let me see, because you know what? This might be it. I'm searching for the word zoning. Wait a minute, what's the date on this thing?
I know, I don't see a date.
There's no date, yeah.
I just see second round of application answers and questions. This is another thing
I just read this, except it wasn't this page. It was the PDF like the other one. Okay. And it's not in here. It was I don't think it's in here. Okay. Unless, because what it was saying, well, what to do, it might be in the first round. What if you didn't get it was something they issued and they were like, if you did not get your zoning in on time, what would happen if you lost your, I think it was in response to the lawsuit. Because it was like, okay, and if you lost your zoning, or what happens if you lost your location?
Right, which is possible.
Mm-hmm. Especially given the amount of time that has gone between the time that the applications were originally due and now, and this was, a few months ago.
I'm not seeing it right away in here, which is why I'm okay with sending that. One of us sending it, maybe you, because you.
Yeah, because I have everybody's email.
Right. But I would like to see the answer if you send it to me too.
Yes, because I'm like, I know I've seen it.
Yeah, because it was during the time that the lawsuit happened for the craft growers.
Mm-hmm.
But I don't have the information anymore, and
you know what I'm gonna do? I've actually got a call with that attorney in the morning. That's something I was emailing. I'm gonna ask him if he has a copy of it.
Okay, perfect.
So let me make sure oh, wait a minute. I'm like, which window? Okay, let me see who asked that question. Oh, this was anonymous. Oh, so I don't even know who it was. So whoever asked the question, if you're still here, or Yashika, do you still have the email that I sent? Because I know I sent it.
Pam asked.
But yeah, if you're still here, whoever asked the zoning question initially, then send me an email and I will make sure that I send a response back to you and let you all know, because it was a very specific thing, and it was like mind-blowing at the time, like, oh wait, this changes everything. Because one of the issues that came up in that lawsuit was that the state needed to be able to provide a remedy, because the people who had, especially those who were applying for craft grow, had acquired property. And so now you've got either acquired or signed lease agreements, or you had all these documents, and you had people that were tied into these contracts that they thought were supposed to only going to be, holding up, holding a hold on, I know that's not the right legal word, but my brain is gone. But a hold on the property, yeah, thank you, option on the property that was only supposed to last like 60 or 90 days because the licenses were supposed to come out. And then around that time frame, it was in the summer, which was when the department said, okay, if you lost your property,
right,
then this, and right. It was on the website. Right. We all remember it.
No, I do.
We all remember it. So we're not all crazy. We didn't all have the same dream. We know it happened. We just got to find what it says, because I have noticed that the department has taken stuff down a few times. Just like now the applications are back up when they were gone.
Right.
So yeah, it's not the round 2, because that was before the applications were due. Right. It was after the applications had already been submitted. So I'm going to find it one way or another. I'm going to find that email. Like a dog with a bone is going to irk me. So, okay, I think we're done. It's almost 8 o'clock. I got some popcorn to eat, a wine to drink, or something. My brain is tired.
I've got popcorn. I've actually got popcorn.
Next time I'm in Chicago, wine on me.
I can't wait. We're definitely going to get to know each other.
Yes, yes, yes.
This was great, you all. I really enjoyed this tonight. I appreciate you. Thank you so much, Queen, for allowing me to be on your space and on your platform. I really appreciate that. And I look forward to more of this.
I do too. Thank you so much for agreeing, for responding so quickly, for being awesome and exceeding everyone's expectations. This has been by far one of the most informative, productive, useful, and many other adjectives that my brain can't think of right now.
Thank you. Thank you.
So, um, I'm sure we will get back together again and do more stuff later.
Yes.
Those of you who have my email, if you need anything else, email me. Whoever has that zoning question, send it to me. Those of you who email me regularly, you know who you are. If you find the email, send it to me.
Yes. And Trisha, I will be in touch with you for a one-on-one after this round of
Yes.
the notices.
Yes, because
for both of us.
yes, because I'm like, all the rest of my life stopped. I was like, listen, I'm sorry, I haven't responded to you. Come see me next Friday.
That's right. Yes.
Yep. Okay.
Okay.
Thanks, everybody.
Good night.
Good night.